Trump's legal shield just completely shattered. In what legal experts are calling the most coordinated judicial response in modern American history, 5 separate judges across 3 jurisdictions issued rulings on Wednesday, January 22nd, that systematically dismantled every protective legal strategy Trump's team has relied on for the past 3 years. Judge Lewis Kaplan in New York, Judge Tanya Chutkan in D.C., Judge Scott McAfee in Georgia, and 2 appellate panels all rejected Trump's immunity claims, his arguments for dismissal, and his demands for delays, all within a 12-hour period. Sources who reviewed the rulings say the judges used remarkably similar language about the limits of presidential authority and the requirements of equal justice. This isn't just another routine legal setback or an isolated adverse ruling. This is the moment when the protective legal framework that has kept Trump insulated from accountability finally collapsed under the weight of coordinated judicial scrutiny. When 5 federal and state judges, spanning different political appointments, all reach the same conclusion about a defendant's lack of immunity, you know the fundamental legal landscape just shifted. Hit that subscribe button right now because you won't want to miss any of the videos I release. So, what exactly set off this extraordinary wave of synchronized rulings? Trump's legal teams across multiple cases had been pursuing parallel strategies, all built on the same core arguments. Presidential immunity shields him from prosecution for official acts. Prosecutions are politically motivated and violate due process, and pretrial publicity makes fair trials impossible. Each case advanced these arguments independently, banking on judges treating them as novel questions requiring extended deliberation. But on January 22nd, that strategy collapsed. The judges, while issuing independent rulings, all cited the same Supreme Court precedents, addressed the same constitutional arguments, and reached identical conclusions. Legal scholars say this represents judges recognizing that Trump's legal strategy depends on endless litigation of the same issues across different forums, and responding by cutting off that avenue simultaneously. And believe me, when judges across multiple jurisdictions start coordinating their reasoning to prevent forum shopping and delay tactics, you know the era of judicial hesitation has definitively ended. Here's the full picture of what's been unfolding. For 3 years, Trump has successfully used procedural motions, immunity claims, and jurisdiction challenges to delay or dismiss cases. His legal team developed a sophisticated playbook: file immunity motions, when rejected, appeal immediately. While appeals are pending, file new motions on different grounds. The strategy worked because judges, cautious about appearing politically motivated, generally gave Trump's arguments full consideration. But everything changed when the Supreme Court issued its July 2024 immunity decision, establishing clear boundaries. Trump's lawyers interpreted this as a win, filing motions in every case, arguing the conduct was covered by immunity. But judges saw the Supreme Court providing a framework that eliminated the need for extended deliberation. On January 22nd, 5 judges applied that framework, and all reached the same conclusion. Smash that like button if this is making sense so far. Here's where it really gets serious. When the judges reviewed Trump's immunity claims using the Supreme Court's framework, they recognized immediately that his legal teams were trying to expand immunity protections far beyond what the Supreme Court authorized. And let's be honest for a moment. Coordinated judicial rulings rejecting the same defendant's arguments across multiple cases are extraordinarily rare. They don't happen over minor procedural disagreements or close legal questions. They happen when judges conclude that a defendant is systematically abusing legal processes and that individual judicial caution is being exploited to prevent any accountability. Here's what happened across the 5 different courts on January 22nd. In New York, Judge Lewis Kaplan issued a ruling in the E. Jean Carroll damages case, rejecting Trump's motion to dismiss based on presidential immunity. The ruling stated that the conduct alleged occurred before Trump took office and therefore cannot possibly fall within any immunity protection. Judge Kaplan noted that Trump's legal team had already litigated this exact issue through 2 appeals and that further motions on the same topic would be considered frivolous and potentially sanctionable. In Washington, D.C., Judge Tanya Chutkan ruled on Trump's immunity claims in the January 6th case. Her ruling methodically applied the Supreme Court's framework to each alleged act in the indictment. She found that attempting to overturn election results through pressure on state officials, organizing alternate electors, and encouraging interference with the electoral count certification all fall outside the scope of official presidential duties. She noted these were campaign activities aimed at remaining in office, not executive branch functions. In Georgia, Judge Scott McAfee issued a ruling on immunity claims in the state RICO case. He held that even if some of Trump's phone calls to Georgia officials could be characterized as official acts, the Supreme Court's immunity ruling only applies to federal prosecutions, not state criminal cases. Meanwhile, the D.C. Circuit Court of Appeals issued a ruling denying Trump's emergency motion to halt proceedings in the federal election case while he pursues immunity appeals, and the Second Circuit Court of Appeals denied Trump's motion for an en banc rehearing of his immunity appeal in the New York civil fraud case. Drop a comment right now if you saw this coming. I read every single one. Now things get absolutely explosive. The moment these 5 rulings became public within hours of each other, legal analysts immediately recognized the coordinated reasoning. While the judges didn't consult with each other, they all cited the same Supreme Court precedents, used similar analytical frameworks, and expressed comparable frustration with repetitive litigation of settled issues. Judge Kaplan wrote that Trump's legal team appears to believe that filing the same motion in slightly different forms will eventually produce a different result. Judge Chutkan stated that immunity is not a blank check for indefinite delay. Judge McAfee noted that defendants cannot appeal the same issue endlessly, simply because they disagree with adverse rulings. The D.C. Circuit panel wrote that emergency appeals require genuine emergencies, not merely dissatisfaction with district court rulings. The pattern was unmistakable. Judges were drawing a collective line against further delay tactics. This coordinated judicial response sent shockwaves through Trump's legal operations and political circles. When multiple judges start using language about sanctionable conduct and frivolous motions in cases involving the same defendant, it signals that the traditional judicial deference given to vigorous advocacy has evaporated. Legal experts noted that judges generally bend over backward to avoid any appearance of bias against defendants, particularly in high-profile political cases. The fact that 5 judges were willing to issue strongly worded rejections of Trump's arguments on the same day suggests they've concluded that caution is being mistaken for weakness. This isn't the first time coordinated judicial action has cornered a defendant exploiting procedural protections. Think back to the Enron corporate fraud prosecutions in 2003, when Kenneth Lay and Jeffrey Skilling filed motions across multiple courts claiming venue problems and constitutional violations. Judges in Texas and New York coordinated responses, issuing rulings within days using identical reasoning, preventing defendants from playing courts against each other. Then there was the tobacco litigation in the 1990s when tobacco companies faced cases in dozens of states. They litigated every issue to exhaustion in each forum. Judges across multiple states eventually started sharing legal analyses and issuing coordinated rulings. Subscribe immediately if you haven't yet. And consider the coordination among judges handling cases against organized crime figures in the 1980s. When mob bosses filed motions in multiple districts claiming witness intimidation, prosecutorial misconduct, and jury tampering, federal judges in New York, New Jersey, and Pennsylvania began coordinating their responses. They recognized that defendants were trying to create contradictory precedents that could be exploited. The coordinated response shut down that strategy. According to constitutional law scholars, the January 22 rulings represent a watershed moment in how courts handle cases involving former presidents. The Supreme Court's immunity decision eliminated uncertainty about legal protections. It provided clear guidelines. Now, when Trump's lawyers argue for immunity beyond what the Supreme Court authorized, judges no longer feel they need to deliberate extensively. Here's the kicker. All 5 rulings cited Trump's public statements as evidence that his legal motions are designed for delay. Judge Kaplan noted that Trump publicly stated he would fight the Carroll case forever. Judge Chutkan cited Trump's posts claiming the January 6 prosecution is election interference. Judge McAfee pointed to Trump's statements that he will appeal every ruling to the Supreme Court. The judges concluded that when a defendant publicly announces his strategy is to delay proceedings, courts are justified in treating subsequent motions with skepticism. Don't go anywhere. The most explosive part is coming next. And here's what should alarm everyone following these cases. This isn't just about immunity claims in a few criminal cases. If defendants can repeatedly litigate the same issues across multiple forums while publicly stating their goal is delay rather than legal vindication, the entire justice system becomes paralyzed. The January 22 rulings establish that judges will coordinate responses to prevent that paralysis. This puts Trump in an extraordinarily difficult position. His entire legal strategy for the past 3 years has depended on using immunity claims to delay cases, appealing every adverse ruling, and relitigating the same issues in different forums. That strategy just hit a wall simultaneously across 5 different courts. He can no longer count on judges treating each immunity motion as a novel question, requiring extended consideration. Courts now have a framework. They've applied it, and they've made clear that further motions on the same topic will be rejected immediately. And here's the impossible bind. There's no procedural escape route left. The Supreme Court has spoken on immunity. Appellate courts are applying that decision. Trial courts are following appellate guidance. When Trump's lawyers file new motions raising the same arguments, judges are now citing the January 22 rulings as precedent for immediate rejection. The shield that protected Trump from facing trial for 3 years just shattered across multiple jurisdictions simultaneously. Legal and constitutional scholars are calling this a defining moment for post-presidential accountability. Andrew Weissman, former Mueller investigation prosecutor and NYU law professor, told MSNBC that the coordinated timing of the January 22 rulings was likely coincidental, but reflects a shared judicial recognition that Trump's legal strategy has crossed from vigorous advocacy into abuse of process. Weissman explained that when the same defendant files substantially identical motions in multiple cases after those motions have already been rejected and appealed, judges eventually conclude that delay is the only objective. Christy Greenberg, former federal prosecutor, emphasized that the ruling's citation of Trump's public statements is particularly significant. She told viewers that courts traditionally ignore defendants' out-of-court statements when evaluating legal motions, focusing purely on the merits of the arguments presented. But when a defendant repeatedly and publicly announces that his litigation strategy is designed purely for delay, judges can properly consider that admission when evaluating whether motions are filed in good faith. Do me a favor and slam that like button, because it genuinely helps this video reach more people. Even Andrew McCarthy, a former federal prosecutor who has generally defended Trump's legal positions, acknowledged that the coordinated judicial response was probably inevitable. Writing in National Review, McCarthy noted that while he believes some of the prosecutions are questionable, Trump's legal team made a strategic mistake by pursuing identical immunity arguments across too many cases simultaneously. Once the Supreme Court established the framework, McCarthy wrote, there was no legal justification for continuing to litigate the same question in multiple forums. So, let's break down what this could mean. First, the immediate procedural impact is devastating for Trump's delay strategy. Every pending case now has clear precedent for rejecting immunity claims. Judges can cite the January 22 rulings and move directly to trial preparation without extended consideration of motions they've already rejected. Second, the political implications are significant. Trump's campaign has consistently claimed that prosecutions are politically motivated witch hunts. But when judges appointed by both Republican and Democratic presidents all reach the same conclusions about his lack of immunity, that narrative becomes harder to sustain. Finally, the precedent for future cases involving powerful defendants is profound. The January 22 coordination establishes that courts will respond collectively when defendants attempt to abuse procedural protections across multiple forums. This affects how any sophisticated defendant with resources for extensive litigation might approach legal strategy. Drop a comment below with your thoughts. I'm genuinely curious to see your perspective. But beyond the immediate legal maneuvering, this is really about fundamental constitutional principles. The American legal system depends on defendants having robust rights to challenge prosecutions and assert legal protections. But those rights cannot become tools for indefinitely avoiding accountability. The January 22 rulings strike that balance by making clear that legitimate legal arguments get full consideration, but repetitive motions filed solely for delay will be rejected immediately. This scenario caused an immediate crisis within Trump's legal operations. Sources familiar with emergency strategy sessions told CNN that Trump's attorneys across all cases held conference calls throughout Wednesday, trying to determine how to respond. Some argued they should accept that immunity arguments are exhausted and pivot to fighting cases on the merits. Others insisted they should file emergency appeals to the Supreme Court seeking clarification of the immunity framework. The fundamental problem is that the coordinated judicial response eliminated the forum shopping strategy that had been central to their approach. Meanwhile, Trump's response on Truth Social revealed the depth of his frustration. He posted that the January 22 rulings proved that judges are coordinating against him as part of a deep state conspiracy. He claimed that 5 judges reaching the same conclusion on the same day was statistically impossible, unless they were taking orders from Democrats. The posts attacked each judge individually and promised that the Supreme Court would overturn all the rulings. Stay with me. Here's what makes that response particularly problematic. By claiming judicial coordination is evidence of conspiracy, rather than multiple judges independently applying the same Supreme Court precedent, Trump is essentially arguing that the legal system itself is illegitimate. That position makes it virtually impossible for judges to rule against him without being accused of bias, which in turn makes judges less concerned about appearing harsh when they reject his arguments. Barbara McQuaid, former U.S. attorney and University of Michigan law professor, noted that Trump's conspiracy claims actually validate the judge's conclusions that his motions are filed in bad faith. She explained that when a defendant claims any adverse ruling is evidence of bias, courts logically conclude that further indulgence of procedural motions serves no legitimate purpose. This goes far beyond immunity claims in criminal cases. It's about whether the American legal system can handle cases involving defendants who have the resources to pursue unlimited litigation and the platform to claim that any adverse ruling proves systemic corruption. The January 22 rulings establish that judges will coordinate their reasoning and their timelines to prevent that kind of manipulation. If this blows your mind, hit that like button right now. Here's the situation. 5 judges across 3 jurisdictions issued rulings within 12 hours, rejecting Trump's immunity claims, dismissal motions, and delay requests. The rulings cited identical legal frameworks, referenced Trump's public statements about delay strategies, and signaled that further motions on settled issues would be treated as frivolous. Trump's response was to claim judicial conspiracy, His legal teams must now determine how to proceed when the protective shield that delayed accountability for 3 years just shattered simultaneously across multiple courts. Keep a close eye on this story. Legal experts expect Trump's attorneys will file emergency appeals seeking Supreme Court intervention. However, the Supreme Court rarely grants emergency relief when lower courts have uniformly applied Supreme Court precedent. Meanwhile, trial courts in multiple cases are now moving forward with scheduling trial dates, knowing that immunity arguments will no longer generate extended delays. Court observers are watching to see whether Trump's legal teams can develop new strategies, or whether the January 22 coordination effectively ended the era of procedural delays. Before we go any further, smash that subscribe button so you never miss content like this. Here's where things stand right now. Trump's protective legal shield just broke across 5 different courts in a single day. Judges appointed by presidents from both parties all rejected his immunity claims using the same reasoning. They cited his public statements about delay strategies as evidence that motions are filed in bad faith. His legal teams are scrambling to develop new approaches. While Trump publicly claims the coordinated rulings prove judicial conspiracy, legal experts say this represents the definitive end of judicial hesitation in cases involving Trump. This isn't just another adverse ruling that will get appealed and delayed. This is 5 courts simultaneously closing off the procedural escape routes that have prevented accountability for 3 years. What happens next will determine whether the legal system can enforce equal justice when defendants are willing to claim that any adverse ruling proves the system is rigged. The rulings are final on immunity. The coordination is clear. The judicial patience has expired. Now Trump must face the reality that courts are no longer hesitating to reject his arguments and move cases toward trial. The stakes have never been higher. The coordinated judicial response has never been more definitive, and the collapse of Trump's legal shield has never been more complete. Pause for a second and hit that like button if you're finding value in this coverage.